Or in the meantime, if they can join in, that'll be great.
Okay. So again, a very good afternoon to all the participants to this lecture, from our colleagues from Head in Paris, our colleagues from Bhutan, our colleagues from Symbiosis Law School in Pune, and our students from Cavendish University, Uganda are also with us, although they are in a different room, some of them in the same room with a couple of others. So my name, for the students who may not know me, I'm called Olive Sabiiti, and I'm the Dean of the Faculty of Law here at Cavendish University, Uganda. The topic we'll be doing today is good faith in the performance of a contract. And the way the lecture is going to be structured, I will talk for 40 minutes, not more than 40 minutes. Since I'm going to talk with the time, so once it's start now, once it's 35 minutes, you give me a shout. And then we'll be having 15 minutes for questions. And just as encouragement, by all means, feel free to send any questions by email if we're not able to handle all the questions during this lecture. I'm imagining that everyone can hear me well.
Yes.
Yes.
Yeah, we can hear you perfectly.
Yes, we can hear you well.
Yes, we can hear you.
Okay, thank you. So the way this lecture is going to be structured, it will be in 9 different parts. I'll begin with defining key concepts, and that is basically defining contract, good faith, and performance. Then I'll be looking at the justification for good faith in the performance of contracts. And then I'll have a little brief on good faith in English contract law, given that we are a Commonwealth country. And then we look at private international law and good faith. And here we'll be looking at good faith under the UN Convention on Contracts for the International Sale of Goods, as well as under the UNIDROIT principles. And this is because we are not only looking at contracts within one jurisdiction, but we are looking at contracts in an international sphere. Then we'll look at the duty of good faith. Then we'll look at the duty of good faith under Ugandan law. We shall look very briefly at the limitations on this obligation under Ugandan law. Again, very briefly, a proposed way forward or recommendation for this obligation of good faith, and then we shall conclude. And I'll dive right in with the definitions. Now, I believe that it is a universal understanding, irrespective of the legal family that you belong to, that a contract is a promise or set of promises that are legally enforceable, and that if violated, allow the injured party to access legal remedies. Now, of course, in Uganda, we have a relatively new piece of legislation relating to contracts, and that's the Contracts Act of 20, duty of good faith under Ugandan law. We shall look very briefly at the limitations on this obligation under Ugandan law. Again, very briefly, a proposed way forward or recommendation for this obligation of good faith, and then we shall conclude. And I'll dive right in with the definitions. Now, I believe that it is a universal understanding, irrespective of the legal family that you belong to, that a contract is a promise or set of promises that are legally enforceable, and that if violated, allow the injured party to access legal remedies. Now, of course, in Uganda, we have a relatively new piece of legislation relating to contracts, and that's the Contracts Act of 2010. And it defines a contract as a legally binding agreement between 2 or more parties. And for a contract to be valid and hence enforceable by the courts, there are certain elements that need to be present, elements that I'm sure we are all relatively comfortable with: offer, acceptance, consideration, capacity to enter into contracts, legal object, and of course the intention to create legally binding obligations. Now, when you look at the main concept that informs our lecture, it is good faith. And I dare say that good faith as a concept is incapable of precise definition. Many scholars have come up with varied definitions of what amounts to good faith, and we can reliably say that there is no universally accepted or agreed definition of the concept of good faith. Black's Law Dictionary, for example, defines good faith as a state of mind consisting of honesty in belief or purpose, faithfulness to one's duty or obligation, observance of reasonable commercial standards of fair dealing in a given trade or business, or the absence of intent to defraud or to seek unconscionable advantage. Now, you notice that there are certain traits that are common in the different perceptions or definitions of good faith. These include things like honest dealing, honesty, fair dealing, reasonableness, and so on and so forth. But in another sense, we can also agree that good faith or bona fide or bona fide, depending on how you pronounce it, is simply the opposite of good faith, which is malafide. It is the opposite of bad faith. So good faith is the opposite of bad faith, and it takes on many different connotations depending on the scholar or on the legal family. Good faith is basically based on the need for fair play at the point of formation, performance, and enforcement of a contract. And it is an absence of intention to harm a legally protected pecuniary interest. I'll give a short illustration to help us appreciate this concept. Assuming we have two people, let me use Sonam and Joanne. Assuming Sonam would like to rent premises from Joanne, but the terms of this rental agreement are that Sonam will pay rent, which is equivalent to a given proportion of his gross earnings. Now, unknown to Joanne, Sonam may have another property down the road to which he diverts customers during the course of the month. Now, in this context, Sonam can be said to be in breach of the obligation of good faith, since in the first place, he did not disclose material information at the time of entering into the lease or rental agreement. And yet it has a huge implication on the lease agreement. And this reminds us of information asymmetries in contracts, where the parties have unbalanced information. One party knows more than the other, to the detriment of the ignorant party, as it were. But secondly, with this undisclosed information, Sonam automatically acquires an unfair advantage over Joanne by keeping away information that is crucial to the performance of the contract. And this non-disclosure affects the amount of rent payable by Sonam. But then thirdly, Sonam's conduct in diverting customers to another location where he has similar business amounts to intentional effort on the part of Sonam to frustrate or unfairly prejudice the contractual undertaking by trying to recapture a foregone opportunity. So simply put, Sonam wants to utilize Joanne's premises while not honestly and fairly fulfilling his side of the bargain, and therefore would say that Sonam's actions amount to bad faith because they depart from a commonly agreed purpose and they are inconsistent with the justified expectations of Joanne to receive the proper amount of rent. Now, I'll quickly add that this illustration is not exhaustive of the principle of good faith, but it gives us a little glimpse into what we mean by the concept of good faith. So good faith, no universally agreed definition, but it has association with connotations of honesty, fair dealing, reasonableness, and the absence of intent to do wrong or to defraud. Now, what is the justification for good faith in the performance of contracts? What is the rationale for arguing for the position or for a duty of good faith in the performance of contracts? Now, the obligation of good faith is based on the need for fairness and honesty in contractual dealings, as I've discussed earlier. Parties entering into a contract must have an automatic expectation that each party will not only deliver on their promise, but will do so using their best endeavors. The obligation of good faith, therefore, serves not only to ensure honest enforcement of obligations, but also faithfulness to an agreed common purpose and justified expectations. So, the first justification in the contract are actually fulfilled or met. Secondly, the duty provides for the unseen or unexpected in a contractual understanding. Good faith rests on the recognition that contracting parties will incompletely specify their obligations because of many limitations. For example, the limitations of language and the inevitability of finite bargaining. This reminds us of the concept of incomplete contracting. It becomes difficult to anticipate or to provide for all possible contingencies in a contract. Therefore, contracts are usually incomplete. Now, whether written or otherwise, parties to a contract can never exhaustively provide for what they want to agree upon. There is always that bit left to common sense, that bit left unspecified, and that aspect left for reasonable expectations. And it is in these instances that the duty of good faith comes in to create obligations that go beyond those specified in the express terms of the agreement. Meaning that even where certain aspects are insufficiently provided for, the underlying duty of good faith in every contract serves to impute reasonable standards in the performance of contractual obligations. And then thirdly, the third justification for good faith is to ensure community standards of decency, fairness, and reasonableness in the performance of contracts. And the argument for this is that whereas contractual undertakings step from private concessions between parties, such undertakings are not implemented in a vacuum. Contracts are implemented in society, and therefore there is a need for imputation of public regulation to achieve decency and reasonableness. Again, I'll give a quick example. Supposing someone, Yasmin, wants to lend Olive a sum of money at an interest rate that we both have agreed upon, whether low or high. If in the enforcement of the contract, it turns out that the interest that was demanded by Yasmin or that was demanded by Olive is unconscionable, then you may find that that contract, although a result of consensus ad idem, a meeting of the minds, it will not be enforced. So in a nutshell, what then is the justification for good faith in the performance of contracts? It is one, to serve a role of moderation of contractual undertakings by ensuring honesty and fairness, providing for the inadequacies of language, and all other contingencies because of incomplete contracting, and ensuring observance of community standards of reasonableness and fairness in performance of contractual obligations. Now, we'll move on to the next bit. What is good faith under English contract law? In the strict sense, English law does not acknowledge the existence of a general duty of good faith in the performance of contracts. And this is compared to the civil law system, where the obligation is expressly codified. English law is generally reluctant to impose a general duty of good faith in contracts. This reluctance is premised on the adversarial nature of the English legal system, which perceives the duty of good faith as highly uncertain, since it is incapable of exact definition. In Interphoto Picture Library Limited versus Stiletto Visual Programs Limited, I cited the case in the reading. Bingham L.J. explained the English approach to good faith. He considered the civil law system's acceptance of an overriding obligation to fair play, a principle of open and fair playing or fair dealing, and he argued or explained that on the other hand, English law has characteristically committed itself to no such overriding principle, but has developed piecemeal solutions in response to demonstrated problems of unfairness. I will also quote Courtney and Fairbairn Limited versus Tollane Brothers Hotels Limited, a 1975 case, in which Lord Denning, in commenting on the duty to negotiate in good faith, said or held that an agreement to negotiate in good faith would not be binding, as it would be too uncertain, and that courts would not be able to properly estimate the damages payable. Similarly, Lord Ackner in Walford versus Miles observed that an agreement to negotiate in good faith was unworkable in practice because while negotiations were in existence, either party was entitled to withdraw from these negotiations at any time and for any reason, such that ultimately agreement was uncertain and had no legal content. So you can clearly see that there is no overriding duty to good faith under English law. Nevertheless, I'll quickly add, there has been a progressively positive change in the attitude by courts in England or in the UK, where judges try to circumvent the traditional position by demonstrating a more relaxed approach towards good faith. In a relatively recent case of 2013, Hampstead 3147 Limited versus Boots UK Limited, the view of court was that even though English law does not recognize a duty of good faith, contracting parties are always at liberty to subject themselves to a good faith standard. But this is not something that an English court will freely infer from a contract. So indisputably, the English law of contract is littered with principles, rules, and approaches which contain what can be seen as the elements of good faith. What might be said to be absent is the recognition of an express norm reflecting an informing principle of good faith. So we've looked at basically English law and the general position of good faith, but we are looking also at contracts where the parties are from different jurisdictions. So we are looking at what can be described as an international contract. So we'll be looking at private international law and the concept of good faith. And as I explained earlier, we'll look at it both under the UN Convention on contracts for the international sale of goods, which I shall hereinafter refer to as the Convention, and we shall also look at the UNIDROIT principles, which I shall just refer to as the principles. So the UN Convention I shall refer to simply as the Convention, and the UNIDROIT principles simply as the principles. Now, the United Nations Convention on Contracts for the International Sale of Goods is an international instrument that blends aspects of English law and civil law in relation to international contracts relating to sale of goods. Uganda is a state party to the convention. We became effectively state parties in 1993. However, the convention does not contain an explicit reference to the principle of good faith, save for general references to of the parties. The CISG, the convention, applies to all transactions involving sale of goods between parties in states which have adopted the convention, but it leaves many issues to domestic law. Now, Article 7, Clause 1 of the convention, which calls for interpretation of the convention with regard to observance of good faith in international trade, was only a compromise that was reached after a number of common law countries objected to the imposition of a duty of good faith on the contracting parties themselves. The objection was based on the uncertain nature of the duty of good faith as considered under English law, and the fact that good faith was generally a moral concept that was susceptible to different interpretations, which cannot be the basis for the formulation of legal principles. Further, this provision, that is Article 7 and Clause 1, was criticized because it would be difficult to provide any sanctions for its breach, because it is very controversial and it poses a lot of uncertainty and unpredictability. The convention, for example, does not expressly define the duty of good faith. Actually, one of the most powerful definitions of the concept of good faith in or under the convention is that given by Powers. And interestingly, the title of his article is Defining the Undefinable, Good Faith and the UN Convention, because it's difficult to define it. But he says that it is an expectation of each party to a contract that the other will honestly and fairly perform his duties under the contract in a manner that is acceptable in the trade community. The duty of good faith, he continues, is an international doctrine that requires parties to an international transaction to act reasonably as they would expect the other to act. And from those of you who read the Bible, the Holy Book, it is also written that good faith is a lot like the golden rule. Treat others as you wish to be treated. Performing contract duties in a manner which is honest, fair, and reasonable will almost always be considered good faith performance. Thus, it has come to be generally accepted that the duty of good faith under the convention is in the first case to be utilized merely as an interpretative tool in the application of the convention itself. Secondly, the progressive approach to the duty under the convention is that it is actually an underlying principle under the convention which needs to be obeyed in the formation and performance of contracts. But until revised and clarified, which is arguably an uphill task, the duty of good faith under the convention remains subject to a huge debate that has not been settled to date. Hence the conclusion that Article 7, Clause 1 under the Convention is highly controversial. I will not say much about good faith and the UNIDROIT principles simply because Uganda is not a state party to the UNIDROIT principles or to the UNIDROIT statute. The latest edition of the UNIDROIT principles of international commercial contracts, the latest edition is the 2016 edition, and it is argued, and rightly so, that under the UNIDROIT principles, hereinafter referred to as the principles, they actually cure the ambiguities of the convention in as far as the obligation of good faith in the performance of contracts is concerned. However, unlike the convention to which Uganda is a party, the principles are only applied persuasively by Ugandan courts when resolving matters concerning international commercial contracts. In a 2018 case of Deluxe Enterprises Uganda versus Uganda Leasing Company Limited, a justice of appeal observed or acknowledged that even though Uganda is not a party to, in that case he was referring to the UNIDROIT principles on international financial leasing, he said he was inclined to seek guidance from the treaty and on the model law. Therefore, even though Uganda is not a party to the principles, guidance can be sought from such internationally accepted pronouncements in resolving international commercial contracts. Now, the preamble of the, okay, I will not go on, I will not say much again about the principles, but I'll just say that as compared to the convention, the duty of good faith under the principles is very clear, succinct. The only limitation is that Uganda is not a party, but that the principles can be utilized to offer guidance in international contracts. Now, I'll spend the rest of the time talking about the duty of good faith under Ugandan law. Uganda is a Commonwealth country. It more or less follows the English common law system. In Uganda, contracts are governed primarily by the Contracts Act of 2010. However, there are also other laws such as the Sale of Goods and Supply of Services Act of 2017. The Contracts Act of Uganda does not contain an express provision imposing a duty of good faith on contracting parties. This is because of the common law standing, as earlier discussed. Uganda heavily relies on common law doctrines. Therefore, its stance on the duty of good faith is not surprising. The above notwithstanding, traces of the concept of good faith can be found within the Contracts Act of 2010. I'll give a few examples. There is a general obligation to perform under Section 33, subsection 1 of the Contracts Act. Parties to a contract are expected to perform their respective promises unless the performance is dispensed with or excused under the law. The above provision is a representation of the concept of good faith, since it obliges parties to deliver on their respective obligations as stipulated under the contract. The other one is fraud. Fraud is a vitiating factor in many jurisdictions. Under Ugandan law, fraud once proven makes a contract void. This is in Section 15 of the Contracts Act, where a party with the intent of deceiving or inducing another party to enter into a contract does any of a series of acts deemed to be fraudulent, then that contract is void. Again, these elements of fraud demonstrate the duty of good faith in contracts, even if the duty is not expressly stipulated. Now, there are two other areas: undue influence, mostly under Section 14 of the Contracts Act, However, I would like to add, maybe I would instead suggest that I would like to delineate the scope of this lecture and qualify that I have considered good faith in contractual relations and not in fiduciary relations. Because as we all know, good faith in a fiduciary context owes deference to the weaker party. So if the legal relationship is one involving a trust or a fiduciary relationship, like in the cases where there is undue influence, the notion of good faith takes on particular attributes that are well known and which are not the subject of this lecture. The usage of the phrase good faith in this equitable context should not give rise to the notion that in a commercial non-fiduciary context, it carries with it the obligation upon a contracting party to subordinate its interests to those of the arm's length contractual counterparty. That is not the case. The possibility of confusion with the incidence of faithfulness of the equitable fiduciary and contractual good faith have led some to use different nomenclature. So some people have referred to fair dealing or fidelity to the bargain just to avoid the confusion or conflicting good faith in an equitable fiduciary relationship and in a contractual relationship. We also have Section 91 of the Contracts Act, which talks about good faith in bailment contracts, good faith in agency contracts, and even good faith in employment contracts. Under the Contracts Act of Uganda, there is also Section 43, where there is an obligation to perform reciprocal promises agreed upon in a given contract. Then, of course, we have one which has a running theme throughout the common law, and those are contracts uberima fide, contracts of utmost good faith in insurance. And in Uganda, of course, these ones try to avoid moral hazard in the process of contracting, where one party will take more risky behavior because they will not bear the consequences of that behavior. In Haji Kavuma Harun versus First Insurance Company Limited, 2013 case of Uganda, while applying the principle in Carter versus Bohem on utmost good faith in insurance contracts, court held that non-disclosure of information by the plaintiff to the defendant was an irregularity that went to the root of the insurance contract. So basically, that is the scope of the duty of good faith under Ugandan law. The Contracts Act or the legislation does not come out expressly to make provision, but there are provisions here and there that can have imputations to the duty of good faith. I'll just speak very briefly, because I'm out of time, on the limitations of good faith under Ugandan law. What are the limitations? And there are majorly two limitations. First is the role of courts in interpretation of contracts. It is the position of Ugandan courts that the role of courts is to enforce what has been agreed upon by the parties and not to redraft contracts for the parties. Courts, therefore, will refrain from imputing terms and conditions that have not been agreed upon by the parties. Hence, the classic statement in the case of Sharif Osman versus Haji Haruna Mulangwa, where courts observed that, where it was held that courts will not make contracts for parties. They will instead give clear effect to the intention of the parties. So the first limitation is that courts, the role of courts in interpreting the provisions of contracts by parties is limited. Courts will not make contracts for parties. The second limitation is the evidential rules under the Evidence Act of Uganda, which was in the preliminary reading. Section 91 of our Evidence Act more or less codifies the parole evidence rule to the effect that no other evidence shall be given in proof of the terms of the contract where the actual terms of a contract are set out in written form in a document. So that excludes all other implications, all other terms, whether they are terms that impute good faith. If they were not expressly covered in the written document, then they cannot be considered. Therefore, the Ugandan position on the obligation of good faith is arguably a mixed one. The duty can be traced under several aspects of Ugandan contract law, as explained previously. However, there are express limitations to the duty, not forgetting the express bar under English law. I'll omit the way forward in the interest of time, but I will conclude and say that it is the reasonable expectation that each party to a contract will not only perform their stated obligations under the contract, but will do so in good faith and to the best of their abilities. At every stage of contracting, parties are expected to observe the underlying obligation of good faith, whether expressly provided or not. Whereas English law does not expressly recognize this duty, it can be rightly argued that under English law and equally Ugandan law, there are traces of good faith obligations as explained earlier on in the discussion. After all, it is impracticable to totally exclude the obligation of good faith in contracts. I would like to thank you very much for your kind attention. I have not gone into the benefits of adopting a unified position of good faith, but that's okay. And then I would like to request any questions that members may have in the remaining minutes. If members have any questions, I will take those questions now. But like I said earlier on, if we're not able to deal with these questions, or if you come up with a question later on, by all means, feel free to write to me on my email. You can to my email, which is clear in the email I sent with the preliminary reading, or sabiiti@cavendish.ac.ug, and I'll be able to address those questions. So I can see that most of the participating colleagues are on mute. If you can please unmute so I can hear your questions, or at least indicate that you have heard me say what I'm saying.
Okay.
But thank you very much for your kind attention.
Thank you, Professor.
Thank you very much. Are there any questions, please, that I can? Seems like a question is about to come from your name. I didn't get your name. Yes, the video at Symbiosis. Is that a question coming through?
Yeah, we're just looking through the notes to know where her doubts lie. So just give us a minute.
Okay, that's okay. Yasmin, anything from head school in France?
Yeah, I have a question.
Yes,
so
please.
let's say you're selling an item at a given price, and I know that this item is worth way more than the price you're selling at.
Yes.
But I'm not saying anything, and I'm buying the item at the given price, at the price you told me, and I'm paying with installments. So I'm not paying at once. So the performance of the contract is not, I'm not performing the contract at one time, but so, and at a moment you realize that the item you sold me was worth way more And you know that I knew. Can you argue that I contracted in bad faith because I knew that this item was worth more?
Yes, thank you very much, Yasmin. I think herein lies the difference between and the duty of good faith in civil law jurisdictions. Now, for example, in the Contracts Act of Uganda, which is mostly leaning towards, of course, the common law legal family, there is a rule of consideration, which is really the price that at which you're buying the item, the overpriced item, in your opinion. And what the rule says is that consideration need not be adequate. Consideration can be sufficient, but it need not be adequate. So that is one of the aspects that you're looking at. So if you're paying me too many French francs for a lowly priced item, consideration need not be adequate. What is important is the notion of freedom of contract. Have the parties agreed to the bargain? Is there a meeting of the minds? So as long as parties have agreed to the bargain, then you cannot turn around to say that I contracted in bad faith. And
Okay.
I will not impose any duty on you. I will not be found in breach of any duty of bad faith because you agreed this transaction. So there's the notion of freedom of contract and notion of agreement to a contract. Although I bear in mind, and I mentioned it, that sometimes in transactions, although the parties need to conclude their own bargains, these
Yeah.
bargains do not happen in a vacuum. They happen in society. And sometimes issues of unconscionability may actually arise. The fact that the transaction has not been conducted in a ethical manner. The example I use is money lending, where if you ask for a very exorbitant interest rate, it may be deemed that actually that interest is unconscionable. But again, that can be supported by legislation somewhere. Did I answer that, Yasmin?
Thank you.
Okay, thank you.
Yes.
Any yes, please?
Yeah. First of all, Professor, thank you for that brilliant lecture. Can you hear
Let
us?
me get your name.
Um, I'm Tarish. Tarish.
Tarish, did I meet you when I came to Pune?
Yes, ma'am.
Yes, I remember you on the bus, and that is why I asked. Good to see you.
Good to see you again, ma'am. You lived in Hayat. I was in Hayat too. I was
Yeah,
in charge
lovely.
of. Yes, ma'am.
Yes, I remember you. Good to see you. I'm really excited about seeing you.
Thank you so much, ma'am. Really nice to see you again. And thank you again for that lecture.
Okay, thank
Ma'am,
you.
you made an excellent point about limitations of language and finance in the beginning.
Yes.
So, after going through the lecture, after listening to the lecture, how would you say to ascertain that whether or not such limitation of language it has resulted from a bona fide mistake or has it been due to a deliberate mistake? So, how would you how in the context of good faith, how will we distinguish that? Because it becomes very difficult.
Yes, thank you very much, Tanish, for your question. Now, maybe what I need to emphasize or to clarify is the limitation that I was referring to, because that is really important. The limitation that I was referring to is incomplete contracting, which happens in all instances. Because take an example, you enter into a contract, you are unable to know all the possible contingencies that may arise and on which your contract depends. So, for example, limitation of language may be one of them, but that can actually be cured because you see, you're not compelled to enter into a contract. You have time to consult and that kind of thing. But contracts can never, ever provide for the full spectrum of possibilities that may happen in a given contract. So because of that incomplete contracting, that is where it becomes a justification, really not a limitation, it becomes a justification. So we then impute good faith on the other party. So we expect that if I'm contracting with Tanish, then we are really acting in good faith. But that does not do away with all the other rules as we know them, relating to, for example, mistake, or relating to dishonesty, or relating to fraud. All those other rules as we know them remain. But we are saying good faith as a duty would be good to help us in instances of incomplete contracting, because then where there is any doubt, the parties can fill the void knowing that each party is acting in good faith. But with interpretation though under English, because under English law or common law legal systems, they are serial legal systems. So parties looking out for their own interest. Each party looking for a good bargain. So it becomes a very thin line between observance of the duty and not.
Doctor.
Thank you so much.
Doctor, we have a question.
Yes, thank you very much. Is there any other question?
Yes, doctor, we have a question.
Okay, there's a question from Uganda. Yes, please. Who is asking? Is it Julius?
Yes, doctor.
Yes, please go on.
I want to get your opinion whether there is need to adopt a globally acceptable instrument in relation to good faith, and if yes, is it sustainable given the different legal jurisdictions in different countries?
Thank you very much, Julius. Actually, it's a bit of my lecture that I did not touch on, but if you look at the preliminary reading that I shared, and even in the other additional reading, you'll find that the convention on contracts for the international sale of goods, that is the CISG, you'll find that actually what it was meant to do was to create certainty, was to create predictability, and to allow a blend between the civil and the common law legal families. Now, when it came to good faith, all compromise was lost. The parties failed to agree. It would actually be very interesting reading to see the history of Article 7, Clause 1 of the Convention. People were not agreeing, especially people from the English law or the common law legal family, because they feel that good faith is a moral obligation. They feel that good faith is uncertain. What is good faith anyway? The English say they don't even know what you mean by good faith. So how then are you going to enforce such a duty? And yet from the civil law legal family, they are persuaded that, and that includes the United States of America, they are persuaded that the good faith should actually be an obligation. But there is, of course, we lost the uniformity that was sought to be achieved under the convention. That uniformity, however, was acquired under the UNIDROIT principles. The UNIDROIT principles are very clear on the duty of good faith. Unfortunately, they have very few members to the UNIDROIT principles, but it is certainly good because it would allow uniformity in international transactions, but that does not stop individual parties from actually adopting those principles as a part of their rules or as part of their obligations to a contract. We have 8 more minutes, so if there are any questions, I can still answer those. So it would definitely be a good thing to conclude on the question from Uganda, because it would allow uniformity, certainty, predictability in international transactions, and parties would also be comfortable that their reasonable expectations will actually be met. I think I'm missing a law school because France, Symbiosis, Bhutan. Do we have anyone from Bhutan?
We are here, Professor. We are here.
Yes, please. Would you like to? Do you have any questions?
No, Professor. Our doubts have been cleared by the questions which have been asked by the previous students. So we're grateful for a very insightful session.
Okay. Okay, so thank you so very much for listening in. I'll reiterate that I'm very happy to take any questions that you may have from any of the law schools. Simply drop me an email at sabiiti@cavendish.ac.ug. And in case you missed that, it is the email that I use in sending the reading materials. So thank you very much. A lovely afternoon. Good to see you again, Tanish. I'm excited because you remind me of Pune. So good to see you all. Thank you for all the teams. Thank you to all our facilitators, the professors who do a lot of work behind the scenes. And I'll also definitely share a recording of this lecture as has been customary. A good afternoon and goodbye.
Goodbye. Thank you so much.
Thank
It's so
you.
nice to see you again.
Thank
Thank
you.
you.
Bye.
Bye.